state. We have to start speaking about what's happening with this surrendering of powers of sovereign powers for each of these states. In order for this international society to work, we need each of the sovereigns to start yielding a little bit of the powers into something else. Let's remind us that at that moment, historically, we're not speaking and we're not talking about democracies, except for France at some points, but most of them are kings that are sovereigns in the most Hovian way. So what is going to happen is that the states are willing always to yield the least powers into the international community or into the international law system. And this yielding on sovereignty is going to be adapted to the needs and to, let's say, the vocation of each of the states. I can remember, and this didn't happen to you too young, but there was a time in which there was Soviet law that came from the URSS, from Russia, from the Soviet Union. And it was strange because if we're talking about the international arena, then Soviet law did not recognize what they call bourgeois law. So meaning that any kind of principles of free market or protection to international investment was prescribed and was denied by the Soviet Union. However, they did have this kind of limited surrendering of sovereignty. And if we can recall de Vischre, he tells the theory that each and every one of the states is going to have this kind of functionality or functional cession of sovereignty in order to create the most convenient kind of international law arena for their own purposes. Now, if we're talking about this yielding of sovereignty between the states to create a set of rules in which they are all going to abide, then the problem is what kind of thing they're creating, what kind of law they're creating. And in this moment, we have the confrontation of the ideas of Austin that says that international law is not positive. For Austin, a law is only positive where it has commands, and when the commands can actually bound and compel the receivers of the law. As far as Austin can see, or what he's presenting to us, is that in this case, international law is not a proper law because it does not entail a command to each of the sovereigns of the states in which is deferred, as it requires according to him two things. First, in somewhat the agreement to the rule by the sovereign, and second, that it must be recognized, and is mostly recognized in a jurisprudential matter. So as it is a kind of soft law, he calls this as an improperly so-called law, completely disregarding the possibility of having a completely independent international law as a subject. However, Kelsen then tries to attack this by telling us that there is some kind of coercion in international law. He starts speaking about the difference between socially and the social, religious, and moral kind of rules, and asserts that the kind of sanctions that implies breaking any of those kind of rules are not in any way similar to the breach of an international obligation. Hence, he establishes that there is some kind of coercion on international law, in as much as we can, in which we can find some kind of validity for some of the for some remedies when there's a breach, as it can be self-help, or as it can be the confirmations or retortion. So, according to Kelsen, this is the way in which international law finds self-contained coercion within the community. So that's basically the one of the issues that they're going to start finding, and they're going to find all the way until I will say around the first half of the 20th century, and is that we don't have any kind of superior enforcer where we're speaking about international law. International law has a decentralized system of sanction that is organized by its own members. So instead of having a sovereign or a sovereign power decide whether or not something is considered a breach of the rule and what is going to be the punishment or the sanction to this rule, when we're speaking about international law, it is the same members of the international community, those who are going to organize, which are going to be the sanctions and which are going to be the punishments of breaching the rules of breaching a rule of international law. Let's say, for example, if a state, and I'm going into the World Bank, but if a state decides to breach a rule from any of the treaties signed for the World Bank, then the sanction is that they are going to stop any kind of loans. So, for example, if any of the countries that are party to the World Bank, that is almost every country in the world, decide that they're going to seize in a discriminatory and non-compensated way any kind of foreign property within their own states, they will find a sanction that is actually enforced by the mutually agreed enforcers for those kind of rules. In this kind of basically a yielding of the powers for all the states in organizing a common arena. Then my next question would be, how come if international law can be considered only the expression of the municipal constitutional law of the states? And this goes all the way back to Hegel, in which he stated that basically international law does not exist as a corpus juris, or it only exists in as much as the constitutional law of each state recognizes the possibility of existence of international law. And as such, international law is only an external expression of the constitutional law of each of the other states. However, this kind of vision does not consider the distinction that we have in this kind of external expression of constitutional law with the interstate law. That means that there is a law within the constitutional order of each of the states in which they do recognize the existence of international law. Some of them, as in the United Kingdom, they incorporated the international law into the constitutional frame. However, this doesn't solve the question of what happens with interstate relations. And as such, we can speak and we can talk about the existence of an international law that is regulating interstate relationships. And then finally, if we're talking that at least on its genesis, if international law is created by the will or by the yielding of powers and sovereignty by the states, then how can a state submit itself to international law? Well, it's in a process, and you're going to start finding this in almost every kind of thing that you're going to see when we're speaking about international law. And it's that we don't have a code, we don't have in the civil tradition, we don't have a corpus juris. So what we have to do, and we have to try to do, is to try to find the evidence of the existence of rules that are going to apply within the international law. So we can actually try to dig out and try to see the evidence of the submission to international law, or into an international rule of a state, first by recognition of that own state constitutions, for example, for their participation and how they have submitted to this or to a certain kind of rules. If we're speaking about diplomatic debate, their work on international organizations, and their work and case law on international tribunals. But as I said, the problem here is that we don't have a corpus juris. We don't have a written set amount of rules that are going to apply. So what we try to do, and we are going to try to do, is to find evidence of that, of the existence of a rule of international law. I'm not you're going to see this in, I believe in the following sessions. There's a session only for source of international law. So I'm going to try to just give you a very quick introduction, so to speak. And the first thing is that I'm not sure if what we are looking, or what you actually would like to do, is the sources of international law. Because the source of the obligations, the source of the rule of law, is completely non-important. But what we need is to see the evidence of the existence of that rule of law. It's to make an example. While arguing before a court and while studying international law, we don't need to go to the spring water, and we don't need to go to the exact place in which the water is coming out to the stream. But we need the evidence that the water exists and the stream exists. So while we're talking about Article 38 of the Statute of the International Court of Justice, we have to consider that this is a way in which that court decided to codify the way in which contending states presenting a case might present the evidence on the existence of a rule of international law. And such, I would say that calling them sources of international law will not be completely correct, as in any event. The only thing that they're going to do is to prove or to evidence to a court of law that there is a certain rule, or how that rule has been applied within the international arena. Now, first of all, we have to understand that this is only circumscribed to the International Court of Justice. There is a long debate, and there's quite long debate, whether or not there are some kind of different or heterogeneous sources of international law, as a unilateral declarations from states, for example. As long as they are, or they can be considered the expression of the will of a state to be bound, they can be considered also a source of international law in some way. In some other, and depending the case, it can be incorporated into international customs, or even into convention. But as long as the ICJ is concerned, these are the ways in which, then again, evidence is going to be presented into there. Now, if we go part by part in these sources of international law, we can see international conventions, international customs, general principles of law recognized by civilized nations, and subjects to provision of Article 59, and this is very important for you, judicial decisions and the decisions of the most qualified publicists of the various nations as subsidiary means for the determination of rule of law. We can see that first, and as I told you, they're not talking about sources of international law. They're speaking as the determination of rules of law. So we're speaking about evidence. Second, this is following a very logical order in which the rules can be evidence into any kind of court. First, the international conventions that are actually signed between the two parties that are party to a contention or to a controversy. This is the way in which they are actually going to be able to enshrine or to bring light into a certain obligation between the two contending parties. As such, the treaty should be considered one of the primary evidences or sources of international law. Now, it is kind of strange when we're speaking about treaties, because treaties actually were born out of customary international law. There was not a codification of a treaty or what was a treaty or the rules of signing and the validity, ratification, or even denouncing a treaty before the Treaty of Treaties or the Vienna Convention on the Law of the Treaties of 1969. So widows on the 18th century tries to bring us a customary definition of what is a treaty. For widows, it can be any kind of agreement finished between two or more subjects of international law, whose objective is to produce legal rights under international law. And from that, we can start trying to get each of the parties of the elements that might be a treaty. First, that it is an agreement. And if we're speaking of an agreement, then we're talking about that what French will call concorde de volontés, or that there are two wills of different states that are reaching an agreement. And this is an expression of their consent to be bound by this exact set of rules. Second, it speaks about that it should be signed or be entered into between subjects of international law. This meaning that we have to make a distinction of when a state or the official of is acting in a sovereign way, so to speak, and when is acting as a private individual. States can also sign documents or international obligations with private parties. For example, if they are contracting maybe the legal services of Claudia, that is not going to be a treaty, but that is, as Verhoeven told us, is an internationalized agreement. An internationalized agreement in which the state is not acting as a sovereign state, but is acting only as a private individual. Now, then, after this, all these customary things and problems, we have the treaty definition of the Treaty of Treaties at the Vienna Convention of the Treaties, and you can actually go and see it on Article 2.1 paragraph A, and and it's very beautiful. We also have to make a distinction between lawmaking treaties and contract treaties. Lawmaking treaties, for the case of international law, will enshrine and will set the rules between the states. A contract treaty does not create law. A contract treaty may be applied within the framework of a lawmaking treaty, may generate rights between those states, but it's not enshrining exactly which are the rules, or is not recognizing rules of international law. That's to say, for example, the agreements that are signed between or inside international organizations as the OECD or the WTO, most of them are contract treaties in which there are no new set of rules or new set of rights between the states. However, the constitutive treaties for both the WTO and the OECD, then we can have that there's a lawmaking treaty in which they establish the rules for all those organizations and how are they going to be conducted, and the rules that all its members have to comply with. Finally, and to actually end up with this, with the treaties, please bear in mind that if we're talking about treaties as an evidence or as a source of international law before the International Court of Justice, the only treaties that are valid are the treaties between the disputing parties at the ICJ. So if you do have a treaty, or you want to show a treaty in which one of the parties is not a party, you are not able, or you are precluded to present it as a treaty. Most probably is going to be part of customary international law. This, I'm almost sure that you already saw it, that you already know it, and it's very, very easy for you. Customary international law has two elements. One material that is the repetition. But sheer repetition is not going to be enough. This repetition has to be carried by subjects of international law. It has to be carried out in time. That meaning that over a certain period of time, we have to see this repetition, and it has to be also carried out in space. That means that it has to be measured on the amount of dispersion that we have on this repetition, because it is going to be completely different if we're speaking about a regional customer, or a universal customer. In this process of creation by repetition of customary international law, we have to consider whether or not we're going to abide to the possibility that there's a persistent objector or a subsequent objector, and which are going to be the consequences of being one or the other. The main difference is that the persistent objector is going to decide, or is going to object to the formation of any kind of customary international law rule while it is being formed. And the subsequent objector is going to try to deny the existence of the rule, but is not going to participate in a negative way while this rule is being formed. In any way, when we're talking about the material event or the material part of customary international law, we need to prove, and we have to show evidence of this repetition. Showing evidence of the repetition can be drawn up from the acts of the states in which we are claiming that a customary rule of international law exists, whether in international or in drawing international conventions, their participation on the international fora, or the incorporation of certain rules of uniform law in different legislations. There's also this formal element for customer international law, and it's the opinio juris. Most of the time, you are going to find troubles trying to show that there's opinio juris, were claiming that there exists a rule of customer international law. First, we talk about that if those treaties, or if the treaty that you're claiming, it is not signed by the contending parties at an ICJ controversy, it shouldn't be presented as a treaty, as a source of international law within the framework of Article 38.1 of the statute. However, it can be shown as the evidence of a rule of customary international law. It can be shown as the feeling of a certain amount of states that they consider that rule of customary international law as obligatory. And there's also the possibility to show a treaty that is only enshrining a rule of customary international law. The most clear example of this is the Vienna Convention on the Law of the Treaties, which tries to enshrine the customary international law and codifies it into this treaty for treaties. This doesn't mean that treaties were not obligatory or were not binding before the signing and entering into force of the Vienna Convention. What it means is that now we have it on black and white, and we have it enshrined, and we have these customary rules enshrined at the convention. Now, let's say that those were the main or the most or the principal ways in which you can show evidence into a case before the ICJ, and that's only because it is the way in which is going to be more and more evident the existence of a rule of international law. Fitzmaurice actually disagrees and believes that as there is no hierarchy between the Article 38, there's no, or we cannot actually consider that these following sources can be subsidiary of the others. Actually, what I would say is that what we're going to use general principles of law and teachings of public exist and the precedents is trying to fulfill the voids that are left within customary international law and the treaties. So general principles of law, actually what they do is that they're going to limit the power of decision for an international judge. Most of the judges in quite most of the systems, and most probably in places like the US and the UK, are allowed to present or to decide not only based on the law, but they are allowed to decide upon their own criteria, on what they believe that is true. So if the national judge uses their criteria, the international judge is prescribed to use its own criteria, but instead, if there's a void or obscurity on a rule of law, he has to use general principles of law. Now, the first time we start hearing this is actually in 1794 in the Anglo-American Commission on Reparations, and it is what I do think it is. It's the commission is a commission that was established between the United Kingdom and the United States in order to pay for the reparations due from the War of Independence. The problem with general principles of law is that they have to be transposable to each and different jurisdictions, as they have to be considered, they should be considered the most logical or the only solution to a certain power that has been presented to you. And so we can make a sort of very broad and raw classification on which kind of general principles of law we may encounter. One of them is there are principles of law that are attached to the general conception of law by itself. For example, we can talk about abuse of right and good faith as it has been presented at the Jessup factory. We can speak about the prohibition or the proprium turtitude principle also reflected at Jessup factory, or a principle of legitimate trust as it is on Portillange and Smith Corona. Then we can speak about general principles of law that apply as contractual law that is being transposed for treaty matters. For example, the concept of force majeure is considered a general principle of law in the indemnification from the Turkish war case. You also are going to have some principles of law that refer to the liability of a state and its consequences. The best example that I can give you is the requirement of the existence of a causal link between the actions of the state and the damage that has been caused, as required by the Wimbledon case. And finally, you can have, you can also have principles about the contentious procedure or the court procedure. For example, the existence, there is no part in the statute of the ICJ that speaks about the principle of res judicata. However, it was applied by the International Court of Justice at the Administrative Tribunal of the United Nations decision of 1954, and is recognized as such. Also, you can have equality between the parties that recognize also on the tribunal for the Administrative Tribunal of the International Labour Organization. As you may see, if we're talking about the evidence of the general principles of law, most of them has already been recognized as such by a court after they have decided that there's a void within the application of the law. So I will strongly recommend you that trying to present a general principle of law should be very careful, and at least you should show to the court or to the tribunal exactly what is the reason or what's the authority behind the existence of that general principle of law. It is not enough that it is in Latin. We all like it. It's beautiful, but it won't be enough. And believe me, you don't want to enter into the real justification of why you have a general principle of law or not. Teachings and decisions. If you can read the first bullet, please, and repeat it every day in which you are going to do your Jessup preparations. Cases do not make law. International law is not jurisprudential. Article 59 of the Statute of the International Court of Justice establishes that case law is only binding upon the contending parties. It is not binding upon anyone else. So it is beautiful that you are able to quote and present lots and lots and lots of cases. If you cannot actually present the rationale of those cases and why the situation and the solution offered by that case is in any way similar to the case that you have at hand, then I will strongly recommend you to refrain yourself to present case law. Further, you have to recognize and we have to understand that there's a difference between case law from national courts and case law from international tribunals and case law by the very same ICJ. So there's also the need for you to make a weighed effort on whether or not you're going to present it as such. Okay. And now we're going to speak about the teaching of the publicist. There's a problem, and that usually the complaint of most international tribunals is that the lawyers presenting the case, the only thing they do is they quote case law and they quote doctrine. Doctrine can be used as a subsidiary means as the evidence or trying to show the evidence of the existence of international law at some other points. But and I have here the example of Judge Jessup at the Renard case, in which he was presented with opposing opinion by the two contending lawyers, one saying that according to Rocius, he was right, the other saying that according to Wittgenstein, he was right. And his answer was exactly that. That's ridiculous. And that's the reason, because doctrine cannot be used in such a way, because you're always going to find the writing or the teaching of someone crazy enough to support your claim. So I will advise caution in trying to present the teachings. And also we have to consider that we have to analyze who is the person that we're going to try to present to the tribunal as doctrine. International organizations. If we're talking about international arena, then we have international organizations. They're a different or a new subject of international law, and we can also trace back their history all the way back to the Treaty of Westphalia. They usually have their own personality, and it's generally recognized on a constitutive treaty in which the member states actually decide to create this international organization. The personality of an international organization can be divided in two ways, one that is internal and one that is external. First, they have, or they may have the capacity to adopt and exercise its own organization and to see the own rights of the members. Also, they may be able to consider or to elect who is going to make or who is going to have the representation of the organization. Also, they may have, and if you say that I'm saying may, is because as international organizations are created by the will of the member states, then they can adapt exactly which kind of these possibilities of personality they may have. And if we're speaking about the exercise of its own right, we're speaking about the possibility of applying certain law to the agreements entered into by the organization. That means that the international organizations also may act as a private subject and enter into agreement not only with the member states, but also with other private persons. Now, we also have the possibility that the international organization is granted with an external personality. That means that the international organization is by itself considered a subject of international law, can enter into treaties, can enter into these other kind of subjects of international law. This is very well treated at the reparation of damages case and the immunities of the personnel. Now, there's a difference, and I would like to just give you an example. The example of the international organization that actually has all of these kind of traits for its personalities is the United Nations. They have the capacity of self-organizing themselves. They have the capacity to even delegate the powers of representations to any person that they considered that they deem possible. They are able to sign international to sign agreements with governments, with NGOs, and they can even sign a lease agreement, let's say, for example, for an office they need. And they are also a subject of public international law. They have immunities, and they can enter into treaties with the states as acting as a subject of international law. On the other side of the spectrum, we can talk about the International Center for the Development of Maize, which you may not have heard about. This is an international organization that only has internal capacity. That meaning that it is only allowed to exercise its own rights as a private citizen, so to speak, but it is not granted with this kind of external power in which they are not able to enter into a treaty. So, for example, for the siege agreements that this center has in Latin America and Angola, they do not sign a treaty, they signed an agreement, a private agreement. Now, happens with international organizations when they die, because they do. From time to time, we can see that an international organization changes and is different from the others. We're talking about how the League of Nations is transformed into the United Nations, how the Permanent Court of International Justice is transformed into the International Court of Justice, how the International Hygiene Office is transformed into the World Health Organization. So, in the succession of international organizations, you are going to see that unless it is expressed at the new treaty of the new organization that is going to assume the rights and obligations of the succeeded organization, then we cannot attribute to them any kind of responsibilities or liabilities that may have incurred by the previous international organization, generally speaking. Now, the international organization also have to comply with a specialty principle, that meaning that they do have implied powers and they do have implied competences. but established by the International Court of Justice in the Administrative Tribunal of the United Nations case, this kind of implied competences and powers are only enough as they are needed to complete the goals of the organization. This kind of implied competences arising from its speciality can be either normative or operational. Normative, it means that they are going to be able to have a uniform corpus juris within the whole organization in which they can establish a regime for its own activities. And if we're talking about operational, that means that they have the actual competences and powers to enter into action and to operate in order to comply or to fulfill the goal for which they have been created. Now, international law and national. I'm very sure that we already know this. There's these contending approaches to this kind of troubles, that it's monism and dualism, in which they consider that there are two contending systems, or there is just one fully integrated system between international law and national law. Actually, it's just a question of incorporation of the international rule of law within the national law, and whether or not it has been contending with it. We also have the problem, or the two expressions for this kind of relationship between international law and domestic law. One is how are going to present domestic law, or how those domestic law interacts with international law. For this, we can see that the Declaration of Rights and Duties of the States of 1949 establishes a principle that domestic law may not be claimed to assert or to justify the breach of a rule of international law. This is called a self-evident principle by the Permanent Court of Justice and the exchange of Greek and Polish populations. And also, there's the possibility that you are going to try to present domestic law as part of evidence, or that you are trying to apply domestic law as international law, as it happened on the Brazilian law in this case, in that the PCIJ decided whether or not apply the domestic decision of the Superior Court of Brazil concerning the expropriation of certain property, and they arise to the same conclusions at the exchange of Greek and Polish populations, in which they consider as a self-evident principle that domestic law cannot be applied. It can be respected and is respected, but it cannot bound an international organization to apply that kind of domestic code. Now, it is the same relationship, but in the other way. Now we can have what happens when international law tries to permeate into the domestic law. And in here, the approaches of each of the states are completely different from one another. For example, for the United Kingdom, in the case of R versus Kuhn, or the Franconia case, it says that domestic court may not apply public international law, referring mostly to the publicists, without arbitration, without habilitation in that domestic law. That meaning that in that case, the United Kingdom court decided that only if a rule of law is domestically incorporated into the English legal system, then it can be claimed before a domestic court. On the other side, you have the Canadian position at the Attorney General of Canada versus the Attorney General of Ontario case, in which the Superior Court of Canada decided that compliance with international law is not subject to any kind of habilitation by national nor provincial laws. On the other hand, you have the hegemony cases and the Paquete Habana cases, in which the United States considers that international law is law of the land and thus is enforceable by local courts, and that international law is basically law. Thanks for all of us. Now let's talk a little bit about jurisdiction. Jurisdiction is the fundamental power of a state to affect persons, property, RC, and circumstances. If we're talking about a court of law, its jurisdiction is a fundamental power to decide upon a controversy that is presented before it. This power and its difference between the admissibility of a claim are very, very well presented at the Lotus case, to which you should be already be very familiar with. So suffice to say that in principle, there are just 4 kinds of jurisdiction that can be asserted: territorial, binationality, universal, and passive personality. Territorial is that the court of the land in which a certain act has been carried out does have the jurisdiction to decide over it. That is completely different to the nationality principle, in which it says that the country of origin of a national abroad that has committed some kind of illegal or unlawful act in the receiving state may have jurisdiction over it. We also have universal jurisdiction. I'm going to just put a pin on it a little bit, and I'm going to go to passive personality principle, in which it says that the country of origin of the person that has been damaged by the unlawful act may assert jurisdiction over that case too. So if we're speaking, there's actually 2 expressions of the same principle. Nationality is talking about active personality, that meaning the person that breaches the rule, and passive personality means the possibility of assert jurisdiction over the person that has been damaged by that unlawful act. And then you have universal jurisdiction. Universal jurisdiction was first recognized by the International Court of Justice at the Barcelona Traction Light and Power Company case as a way to redeem itself from its failures at the Southwest Africa case, in which it decided basically to consider inadmissible the claims by the states, as they considered they did not have standing. And I believe that when we're speaking about universal jurisdiction, that's precisely the point: standing. That meaning the possibility of a state to bring a claim against another state. At the Barcelona Traction case, the court did consider that there were some obligations that were extremely great from the international community. And as such, these kind of obligations, as they damage the whole international community, gave a standing to any country to present a claim before the ICJ. That meaning that with universal jurisdiction, they considered that there was this kind of erga omnes obligations. And be very mindful, I'm not talking about jus cogens, neither the court. I'm talking about erga omnes obligations that allow any state to bring a case before the court, even if they are not damaged directly by the actions of the infringing or breaching state. This was even a little bit upheld by the United Kingdom at the Pinochet trial, in which they decided that universal jurisdiction only applied to give a standing to contending states to bring claims into the ICJ. And so they decided to free him after a couple of moments. So it is a question of debate whether or not universal jurisdiction can be claimed by domestic courts to bring international criminals into their own domestic systems, which well, maybe you are going to have to answer at some point. Finally, we can speak about some kind of or some special jurisdictions that might be presented within the at the international arena. A criminal jurisdiction that, for example, is a kind of subsidiary jurisdiction that applies only when a state is unwilling or cannot assert its own criminal jurisdiction, and only over a certain amount of crimes internationally recognized by a treaty that creates the possibility of that criminal jurisdiction. If you do not have an habilitation treaty to assert criminal jurisdiction internationally, then it is considered that it's going to be a right of the states to consider whether or not certain acts may consider criminal events or not. Further, you may have two general exceptions to the assertion of jurisdiction from one state, one being the possibility of having state immunity and the other having diplomatic immunity. State immunity, we're going to refer ourselves to the possibility of denying the exercise or the decision of a court of law in a foreign state. Then again, in this case, we need an habilitating treaty that allows the recognition of the domestic courts of one state for the decisions or the applications of the enforceability of the domestic decisions of the courts of another state. If not, state immunity is considered generally to apply, and as such, you may have a ruling on a foreign court that is not enforceable in another country. And diplomatic immunity, that refers to the immunities of diplomatic missions, its properties, and its personnel. It's mostly also considered as enshrined on a treaty, on a multilateral treaty, the Vienna Convention on Consular Relations, and the Vienna Convention on Diplomatic Immunities. And it also establishes a limit of which kind of acts can be considered by the receiving states and can subject the diplomats of the sending state into a criminal jurisdiction, giving them also immunities to their properties, and in some cases even to the relatives of the diplomatic personnel. Well, I tried to make a very, very quick exercise of trying to just explain broad, extremely broad generalities for these topics. This is by no way extensive. It is not intended to be extensive, but thank you very much. And I don't know, Claudia, do you have any questions?
Yes, we have one question, and it says, which international organization has both an internal and external legal personality? Yeah. So I figure an example.
I would say that the best example is the United Nations. They do have both expressions. They can organize themselves internally, but they can also sign agreements with other states, and they are a subject of international law. And this has also been recognized at the immunities of the United Nations personnel case before the ICJ. But yes, you can actually have both cases. In most of the cases, you have both. What is hard is trying to see or to find any kind of international organizations that only represents one of the traits of the personality for each state. And well, I think that's been all. Thank you.
I think we have just one more question. For universal jurisdiction, what is the legal standard that countries must meet to be able to invoke universal jurisdiction before the ICJ?
Most of the time is you have to prove the existence of an erga omnes obligation. This meaning that there has been a breach of an international obligation such grave and so severe that each breach damages the whole international community by itself. The example and the example that they tried to put was apartheid at South Africa in the 70s. They'd say that this kind of racial discrimination was of such a great danger and such hurtful for the whole international community as a whole that any country should be entitled to bring a claim against, in that case, was either Namibia or South Africa, the both states that were carrying out apartheid policies, to bring it into the International Court of Justice. Then again, you have to be very careful when you're trying to invoke universal jurisdiction. There's the question of whether or not all these kinds of erga omnes obligations entails jus cogens rules, or if there are completely separate categories of obligations that can be breached and that can arise to the existence of universal jurisdiction over a certain case. Well, I think now that's all.
Yes, that's all. Thank you so much for taking the time out of your busy schedule to be with us. And thank you. It was a very wholesome and good brief of what international law is. So thank you very much.
Thank you very much. And I'm sure that in the following sessions, you are going to address each of these subjects in a more profound manner.